My name is Ken Verkaman, as some of the people in the internet world know. So, at the end of this short program, I'm going to answer people's questions. I'm not going to do it during it because sometimes people have questions that they don't want to know their business, or so. A lot of times, though, and I like to do this twice a year, so the law clerks, I kind of force them to learn something. Is people says, well, why do I need to have a will if I'm married, or all my accounts have direct beneficiaries? I goes, well, number one, there's always assets that don't have a direct beneficiary, and the whole idea is if there's not a will, you're usually causing more stress and aggravation to the family. So even if someone is has 3 kids and all the kids get along, if there's no will, one of the kids they would all have to agree upon who's going to be the administrator of an estate, and the people who are not going to be the administrator have to sign a thing called a renunciation for administration, have it notarized, file with the surrogate. Well, those are for estates where people get along. Sometimes you get someone who's one of the kids that says, I'm not gonna do that. Someone says, well, I'm married, doesn't everything go to my spouse? He goes, well, it depends if there's a first marriage, but that's not really doing planning because eventually the second person is going to pass. If there's no will, or the will is not properly signed or not properly done, then the person who becomes the administrator has to take out a thing called a surety bond, spending $1,000 or $2,000 for it, and the cost of a will is substantially less than a couple grand. If young people who don't have wills but have minor children, I usually say a bald white guy determines who has custody of their kids. Who's a judge of the superior court. So, but most importantly, if someone doesn't do any planning, or it causes stress, aggravation, sometimes lawsuits amongst the family. The surrogates are the first people to say, be careful using these cheap online things, because even though they advertise good in every state, if things are not signed correctly, then the surrogate says, I can't admit this to probate. This is not. Then they have to spend a couple grand and going in front of a superior court judge, and every one of the plaintiff that would have inherited without a will has to be notified by certified mail in writing of the case. So, think about if you have people you like, who would you like to get your money, who not? Welcome, young man. I'll say you. Let's say logistically, one of the few things that good came about COVID is we started emailing all the questionnaires out. The old way, we would, when I first started out, I would say, I would be with a clipboard and writing people stuff down, and then we would have people fill out the questionnaire in their handwriting, but then I couldn't read people's handwriting. I'd say, and listen, I'm an Edison. I can't pronounce a lot of the names anyway, let alone read, because the wife is a different last name from the husband, and then their executor. So that's why it got easier, where we could simply email out a questionnaire, they type it up, and they send it back. Some of the seniors would say, I don't have email, or I'm not good with that. No problem. Let me tell you. It goes, one of your grandkids is going to help you out, because they're good with that. And if you tell them, listen, I'm going to give you $5,000 if you come over to my house for an hour. And if they say, I'm too busy to help you out, no problem. Then you could put in the will, nothing to them, because I asked them to help me for a simple hour. And they said, no, I'm too busy to help you out. Let's see. We get the will questionnaire in. People can pay by credit card, by check. Once a year, someone goes, I pay by cash, and some people on the credit card, they want to pay through an online portal. Hey, no problem. We're trying to make it easy. Let's see. So for most of the time, there's not a reason to drive to the attorney's office to go over what's in the will, because just last week, a fellow goes, I'd like to make an appointment to come in. I go, Mr. Shah, I'd say, you're married, right? Yes. Okay. Are you looking to disown your wife, or do you want her to get everything? I want her to get everything. Good. Okay, Mr. Shah, you have 2 kids, right? Yes. They're over 18. Yes. Are you looking to disown any of your kids? Or do you want them treated equally? I want them treated equally. Mrs. Shaw, I know what you need. Type the thing up, send it in, and then we go from there. Trying to make it as easy as possible. All our other forms now, it's forms that people can type up. If someone says I don't really understand some of the questions, I goes, well, type up what you know, because we've had people come in, I don't understand, and the form would say, what's your name? And it's blank. Type your name in, and And again, some people, because their age or medical conditions, they can't do it. No problem. A family member can type it up, but we obviously need to talk to them ahead of time, and based upon the court rules. And they can't tell us, oh, my daughter knows what I want, or it's whatever my daughter wrote down. Okay, under me, either I'm going to do it right or not do it at all. So you have an executor 1 and executor 2. Our rule of thumb, typically married people make it their spouse, but the rule of thumb for the executor is, can they drive to the surrogate's office, and can they walk up a flight of steps to go to a bank? If they can't drive, etc., we're not anti-old people. I'm realistic. How are they gonna do this stuff? Blind people aren't allowed to drive. We're not against blind people. It's just we're realistic. You have an executor 1 and executor 2. You don't want to have joint executors, because that creates twice as much work in a way. That means 2 people have to do everything. 2 people have to go to the bank, open up an account. 2 people got to sign every check. 2 people got to do everything. Go to the closing. And they could be twins that live together, but why create more work? On the other hand, sometimes you get 2 people that don't agree. Well, then there's no tiebreaker. That means everything has to go in front of a superior court judge. We handled the case where there's 2 brothers, and one brother would say the sky's blue. The other one says, no, it's gray. You're stupid. You've always been stupid. The judge said, fellas, why don't you guys go and have a cup of coffee? Talk about fun things you did as kids, going on trips with your parents. I mean, there was fun times. You shouldn't be fighting, and, fighting over, judge goes, junk, couches, and stuff. Now, the will takes care of your assets that don't have a beneficiary. The will does not change assets that have a direct beneficiary. So examples of that are, if a house is owned husband and wife, automatically goes to the survivor. Will can't change that. If you have bank accounts that are payable upon death, joint tenancy, right of survivorship, automatically goes to that person. If you have CDs and you put down, goes to that person. That's other things passed by contra IRA, 401k, anything, life insurance, anything that you have a beneficiary. The will does not change that. 2 years ago, Mr. M says, listen, I want to do a new will, and I'm taking out these couple people. Okay, fine. We do a new will, and everyone gets at least 3 letters and emails that say that the will does not change who you have your beneficiaries. Make sure you change it. When this fellow passed, he never changed his IRA. The 2 people he didn't want to get stuff got stuff. So it's better to have things done right ahead of time. For your assets that have specific beneficiaries, it's a good idea to help out your executor to get an old-fashioned printout of a piece of paper, even if it's from an email, and that you put it in the will file. That way it helps them out down the road. Let's see. Believe it or not, New Jersey is the probate easiest state. They did away with the New Jersey inheritance tax if it's going to spouse, children, grandchildren, or charities. There's no more New Jersey estate tax. There is a federal estate tax. So for you people out there that have more than $12,500,000, you got to pay a tax. For most of the other people in the United States of America, there's no estate tax. Some people also have what's called specific bequest. What a specific bequest is where you're giving a specific amount of money to someone. So sometimes a lady will say, I want my jewelry to go to my daughter, my granddaughter, my niece, because if the executive, if they're a guy, they're going to bring it to Cash for Gold on Route 18 and says, what do you give me for this junk? I'll say, yeah, what do you give me for my grandmother's ring? I don't want it. Sometimes like the men have specific bequests of like what they think is valuable, like their old baseball cards, or some men were sportsmen and they have like hunting things, and someone needs to if they're getting a firearm, they need to have a firearms ID. Let's say specific, so that's a specific bequest. Then we have the reverse specific bequest. I leave nothing to whomever. You don't leave him $1, you don't give a reason. Last year, a client goes, do I have to treat all my kids equal? He goes, no, you can leave everything to the Yellow Dog Society. What's your concern? She goes, well, one of my sons lives on the West Coast. We don't hear much from him. Well, okay. Did you get a card or a call on your birthday, on Christmas, on Mother's Day? No. Why would that? And I go, why would you leave this bum anything? He doesn't call you on Mother's Day. He goes, geez. I remember one year when I was in college, all of a sudden I go, oh, it's 9 o'clock. I forgot to call my mom for Mother's Day. I'm working at some, Howard Johnson's motel. So I, get the phone. I call Mom, hey, happy Mother's Day. Hope you had a good. She goes, thank you, but Mother's Day's next week. Well, okay, that's good. It's better to be ahead of time than be behind. So remember, it is your right to do with your money what you want, and more people that have kids are not leaving their money to their kids. Why? Because their kids are already grown, have their own. Not because they don't dislike that kid, but they already have their own house and their own whatever. If they got money, they would buy a luxury item, a boat, a fancy car. Sometimes, people say, I'm leaving it to the grandkids because my kids have not put away enough money for college because they're not realistic. I'd say, and I wasn't realistic either. One year I went to this college, University of Scranton. I loved, I got on my wall. I loved Scranton, and I'm getting active in this alumni stuff. And I goes, what? I'm gonna give Scranton $2,000 this year. I tell my wife. She goes, how much have you put away for your own kids? Nothing. She goes, you're going to give $2,000 to some total stranger. Never met. But you haven't put away a nickel for your own kids. Well, having said that, I guess Scranton's not getting a lump of money. We typically have, when there's minor children, we have clauses that say they don't get the money outright. They get some when they're 22, some when they're 25, the balance when they're 30. But the executor can, spend as much money as is needed for health, education, maintenance, support. So that means when people have minor children, both parents are gone, they could say, okay, obviously we're going to pay for grad school. Then they finish schooling, and he goes, hey, got a job. I would like to buy a condo in where I'm going to be working. Okay, that makes sense. On the other hand, the kid's 20 years old and says, listen, college is difficult, and I need to unwind, and I need money so I can take a trip across Europe with my buddies. Trustee goes, you better work more hours on your part-time job because your parents didn't work, so you could goof off. Let's see. We don't want 19-year-olds to get money because they don't. I don't know about people here, but I would not have invested money wisely. I would have bought a red fast car and would have went down to Seaside and bought beers. And so you want to protect. I was telling a fellow yesterday, you want to protect your kids from their new friends, because every single kid. I said to him, every person in Princeton High School, your daughter's starting as a freshman, would know on the day she turns 18, she's getting $950,000, and she's going to get new friends down the road. So when there's minor kids, there's a thing called the trustee. The trustee holds the money. Typically the same person as the executor. The guardian holds the children. So people with minor children, they go, I can't decide. He goes, okay, if you couldn't come home today, who would you want to watch your kids for 2 weeks? I guess my parents. Okay, put them down. Well, they're getting older. Yeah, but they're the best person now. You can always change it down the road. So get your documents done. Don't be a Carl. Carl wasn't put her off. Carl, pre-COVID, sat down with us, and he was, before they eliminated the estate tax, there was an estate taxes due. So I said, listen, I can set it up where you don't pay any estate tax. You split up your money between your wife and you, and we can have a special trust where your money doesn't go direct to your wife. And some people do that. It's a good idea to do it in second marriages, or even some people do it in first marriages, because they goes, listen, if I die, yeah, I love my wife, but why should my money go to her new husband, or whoever she's staying with? But anyway, so Carl's there. Carl was this retired engineer. Those engineers were the kind of people that used to read the manuals when they got a car or a new computer. I didn't read the cover. I like to read more up on this. Carl, you don't need to read anything. I graduated law school. I passed the bar. I go to seminars. I wrote a book. You don't need to read anything. So when I had knee surgery, I read nothing about knee surgery. I didn't want to know. Doctor, have you done this before? Kenny, I've done this like 1,000 times. Okay, good. Anyway, Carl, I want to read up on this. 2 years later, Carl's daughter calls. My dad passed away, and do I have his will? No, Carl never did a will because he wanted to read up on stuff. So, there was a change in the law that made something called a self-proving will. Under the old law, person signs, two witnesses sign, but then the attorney, one of the witnesses would have to sign a affidavit for the county surrogate to say I was the witness. So my grandma's will was done. She passed. We got to locate one of the witnesses, and the lady goes, "Yeah, I used to work in that law office. My fee's $500." I go, $500? My dad goes, "We're not paying you $500. Lady goes, "Well, then get the other witness." "Well, she's dead." "Yeah, my fee's $500. Now, we could have said, "Screw you, we're not paying you," but then we would have had to spend $3,000 on going a complaint, order, show cause, superior court route, so we had to pay that. New statutes called self-proving will. Person signs and the two witnesses sign, see? Then the attorney and notary signs, then they sign again, so everyone's signing twice. Person, two witnesses, the attorney and notary. That way, the witnesses don't have to be uncovered and don't have to do that. So that's a smarter way of doing it, and you don't have to locate the witnesses. Let's see. I knew a law office that they did not do self-proving wills on purpose, so that the people would, the family would have to come back to them down the road. And I said to them, that's the wrong way of doing it. So, and that's important to think about, because a lot of these cheap things online, they are not self-proving wills. And again, they tell, oh yeah, it's valid in every state, but then the family has to go locate these witnesses. Also, if someone does not have a will, the administrator has to take out this insurance policy called a bond. It costs $1,000, $2,000 per year. The will has to have a clause that says no bond required. Otherwise, there's also a bond. And the whole idea is trying to save money. I tell people, I guarantee if you have a will done, you're saving money. I'd say if you have it done by an attorney and the attorney's going to do it right. So again, the cheap things online don't say no bond is required. Okay. After your original will is signed, that is your property. The attorneys don't keep it because it's your property. There's a memo by a directive by the courts, an opinion, but you do it. So it has to be in a place where Executor 1 and Executor 2 can get to it. Okay, so don't hide it unless you think that someone who's an executor wouldn't like it, or someone of beneficiaries and would try to rip it up. You can just have simply a fireproof box and put it under the bed. Make sure the fireproof box is closed with no paper sticking out. My wife's fireproof box, I saw one time there was so many papers sticking out that he couldn't close it. And that's not fireproof. That is fire kindling. And the idea on doing stuff is doing it right. And make sure it's closed. You don't need to have a lock, but because a lot of times when there's a fire, the damage is caused by water. Let's see, if it's open, then the water's damaging it. Let's see, don't put it in a safe deposit box because the executor has difficulty getting to it, and banks are not open on Friday nights, Saturday afternoons, Sunday mornings when you might need it, because you're also putting your power of attorney and living will in there. Okay? So now I'm going to talk about two other important documents. Let's say let me just step. Periodically, people says, I want to get a trust done. And my mother used to call me every other year, I want to get a trust done. I would say, we watching Susie Orman on TV. And she would say, oh, yes. I go, Susie Orman is right. If you live in New York or California, where the probate process is very, very, very complicated. Probate in New Jersey costs less than $200. That's the surrogate fee. So I ask people, why do you think you need to have a trust? To avoid probate. Yeah, probate's not complicated. Well, I was told if I have a trust, then I avoid probate. Yeah, okay. A trust costs $3,000 to $6,000 a piece for a revocable trust. Why do you need to spend all this money? Let's see. Also, it means that the assets are going to be retitled. So the house that is in your name is not going to be owned by you anymore. It's going to be owned by the trust. Assets you have are not owned by you anymore. They're owned by the trust. And then you're creating an extra set of, stuff that tax returns, etc. So there. Now, that's a revocable trust. Is popular in Florida, California, New York, where the probate process takes 2-3 years and costs $15,000. So if you have a condo in Florida, set it by a revocable trust, have it transfer the title to the trust, and that way, 10 minutes after someone passes away, the trustee can do stuff with it. But I tell people in New Jersey, you don't need to do that because New Jersey's easy. Some people want to protect their assets in case they have to go into a nursing home. That's called an irrevocable trust. The assets are transferred. The person can't be the trustee, and then you got to wait 5 years and hope, and not apply for Medicaid. The attorneys that do that, I don't do that, but the attorneys I know that do that usually charge a fee of between 10 and 15 grand because it's very complicated, and it's the you have to be familiar with federal law. And by the way, some people with their work, they have wills paid by what's called a legal plan, MetLife legal plan, ARAG legal plan, legalese. So people I know in New Jersey that work for Johnson & Johnson, Bank of America, Merck. Let me just also briefly touch upon, sometimes in a will, people have their money going to a person, not directly, but in something called a testamentary trust. What a testamentary trust is instead of them getting the money outright, someone gives them money either based upon their need or in increments. So we helped out in a state where when mom did the will, the shares to one of the sons didn't go to him directly. It went into a testamentary trust because he was an alcoholic and, he didn't have a good job. And, so there was a motion filed in the family court by his ex-wife to compel the trust to pay out of the trust fund alimony he owed the wife. And the judge agreed with me, because the reason why you set up these trusts is to have money so that they're provided for over the rest of their lifetime. And believe it or not, these testamentary trusts can't even be attacked by IRS. It's one of the few where IRS can't make a claim on that if someone owes any kind of taxes. People that have special needs, children, usually are smart enough to set up special needs trusts for their children. It's usually the people that have kids that are kind of wayward. I'm hoping that they grow up, but after a while, you kind of know whether or not. Do you think the kid would spend the whole $100,000, $200,000 in the first 6 months? So, those are a couple things that people need to think about. Okay, now let me talk about what is the power of attorney. A will takes care of your assets if you pass away. What a power of attorney is you're giving the power to someone to be able to sign checks, pay bills, etc., do your financial stuff while you're alive. The power of attorney is effective either right away or only upon disability. So we usually recommend that the power of attorney be effective right away rather than only upon disability, because if it's effective only upon disability, a lot of institutions will just say, well, okay, I see a note from a doctor, but how do we know that the person is still disabled? Maybe they're better. The banks are sometimes difficult to deal with in that way. I'd say, yeah. So if it's effective right away, it's a durable power of attorney, and it stays in effect even if someone becomes disabled. If it's effective only upon disability, that's called the springing power of attorney, and only springs into effect if someone becomes disabled. So, my client, Joseph Kenny, he told me legal terms. I'm a carpenter. Explain to me in carpenter language. Okay, fine, Joe. Listen, if it's effective right away, your son, who's going to be your agent, can steal all your money right away. If it's effective only upon disability, he needs a note from a doctor before he steals all your money. Knowing that, you trust your son. He goes, I would trust my son my life. Good. Make it effective right away. Say, this is what I do for a living, and that's the better way. We change our powers of attorney every other year, because sometimes there's a minor change in the law, etc. Some of the banks, for a period of time, were not honoring powers of attorney. They were it wasn't done on our Wells Fargo form, or wasn't done on our First Fidelity form. So New Jersey legislature came down with a law that if it makes reference to the New Jersey statute, they have to honor it. However, it has to make reference to Section 2 of PL 1991, C 46:2B-11. And we're pretty sure these free things that you find, or cheap things you find on the internet, are not going to make reference to New Jersey statute. Have a real attorney do it, and you come out ahead. We also recommend a new power of attorney be signed or re-signed every 5 years. Not because we're making a whopping $100, is because some of the banks will say, this is 9 years old, I don't know if it's still, how do we know it's still good? A will is good forever. Power of attorney does not, there's no statute that says it's expired, but fighting the banks is never fun. Also, sometimes you want to do a new one if your address changes. We used to put the addresses of who the agent was in the power of attorney. Then after a while, it goes, if they're having a kid, is there any dispute who their kid is? If it's someone who's not a family member, because people don't have someone who is in their family, they're not married, don't have any kids. A couple times a year, someone will say, listen, all my assets are going to a charity. Kenny, will you be my executor? Will you be my agent? I go, well, we got to get in writing from you, because it used to be back in the 70s, the attorneys were inserting in. And I put my trusted advisor, Ralph Bershowitz, my attorney, and, guy didn't even know who Bershowitz was, but some people do that. But I do insist that someone prepare what's called a letter of instruction that says, it's a letter of instruction is not a legal document. It sets forth who gets your stuff, what your assets are, and it makes it easier if someone who's coming in that's never been in your house before, what to do. I'm the executor of an estate where, was one of my neighbors growing up. Him and his wife were friends of my parents. When he passed, at least there was something in writing that says, okay, do this, do this, do this, and I knew, where the metal boxes were and what to do. I was lucky that they were organized people. A will does not need to be updated unless you want to change who your beneficiaries are or the executor can no longer do the job. So take out your will every 5 years. You look at it. Is it still what I want? It's important to get a power of attorney done. Let's say under the law, if someone passes away, the law already says who gets their stuff. But if someone becomes temporarily disabled, no one has, even a spouse does not have a right to jump in and do stuff legally. So if someone does not have a power of attorney, they would have to go through an expensive and complicated thing called a guardianship. So in Middlesex County, the probate judge periodically has me as the attorney for an alleged incapacitated person where there was no power of attorney. So again, get this done. Once a week, we get a call from a family member. I need to get power of attorney over mom, dad, or Uncle Joe. No, you can't get power of attorney over anyone. They have to affirmatively give it to you. And we'll say, listen, you can type up the form to help them out, but we need to talk to them. And are they able to say on the phone to me, I want this person as number one, this person as number two, if we're just doing the power of attorney. If they can't do that, then I goes, listen, I'm sorry, but the law is the law. I just can't, take this is what they want. Good, they got to tell me what they want. The last document I'm going to talk about is the Living Will Advance Directive. Someone's in a coma, irreversible condition, some terminal medical condition. They can't talk. They can no longer talk for themselves. As long as you talk, you're the captain of the ship. Let's see. But the Living Will Advance Directive for medical care, you're giving instructions to hospitals and doctors. Hey, this is what I want. Section 8 deals with fluids and nutrition. 95% of people say, listen, if there's no hope for me, I don't want to be, have feeding tubes and stuff like that if I'm not going to open my eyes again and walk the planet. Section B deals with medical treatment, artificial means. 99% of people say, listen, if there's no hope for me, I don't want to have stuff done. And again, it's important because if there's no document, then you're kind of, if there's a couple kids, that becomes a problem because the doctor's going to say, well, I don't know who to deal with. And one time there was a little lady, I was her power of attorney because her husband died, her sister died, she had no kids, and she didn't have anyone. But she never did a living will. All of a sudden the doctor, she's in the hospital, she's not coming out. Doctor goes, okay, should we remove life support today? Well, geez, doctor, I feel bad. I mean, the right decision is for someone who's 92 years old. It's not going to open up their eyes again. But I couldn't even do it when my first dog was was at the end. I had to have my wife go into the vet. No, because otherwise I'm going to bring the dog back. The whole idea of doing a living will is, okay, you've done it. All of a sudden you can't talk. The doctor, listen, this is what they put down in 2023. They don't want machines. They don't want this. They're not going to do it. Give meds to alleviate the suffering, but, don't do anything to keep them alive. People used to be afraid to do a living will because they thought that, well, does this mean that they're not going to resuscitate me if I have a heart attack? No. Like, the EMTs do what's right, but it's where someone's kind of at the end, they can no longer talk. Okay, last three things. Make sure your executor knows where only the original will can be admitted to probate. Some people scan it or make a copy. They give it to the executor too, but let them know where the original's at. The power of attorney, it's a good idea to scan it, email it to number one, number two, and if you have anyone that deals with your finances, financial advisor, accountant, either email or send them a copy. Living will, scan it, you email it to each other, to your agent and your family doctor, or give them a copy. That way they know it is there. See, so for the people that are listening in TV land or on Facebook land, my name is Ken Verkaman. My office is at 2053 Woodbridge Avenue, Edison, New Jersey. And our law office phone number after 10 a.m. is 732-572-0500. Thank you, everyone, and have a good day in TV internet land.